Mm. Give a date. Mm. Motion. What is the urgency? Well, give a date. Some. Mm. Item 33. You want to file reply? Mr. B. Prokasta prays for and is granted 2 weeks time to file affidavit reply. List again on so and so. Give a date. It's okay. If you have no objection. March 27. We are in 26. Huh? Oh, 27 March. Say that. Give a date. They will give a date. Mm, 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 mm. Why? Mr. PD Nair is said to be out of station and therefore, not senior counselor, is said to be out of station and therefore pray for adjournment has been made on his behalf. Accordingly, list the matter on so and so. Give it. Mm. Wednesday. It's okay. It's on motion only. Mm. List on 19th of August 2026 as paid for by the learned counsel for the petition. All right. Okay. Mm. Parties are all represented. They will suffice. Next. Hmm. Last last listed on March. Yes, give a date. Give- Mm, mm. As paid for by learned counsel for the petitioner, 2 weeks time is granted to file reply affidavit to the affidavit in the position of the respondents. 7. Mm. Sorry? Who? Okay. Mr. S.H. Sigdar, learned counsel for the petitioner is said to be out of station. On a prayer made on his behalf, matter stands adjourned. For? Adjourned for? When do you want it? When is he coming back? Adjourned for 2 weeks. All right. Mm. All right. Date? Mm. 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 Okay, you'll get a date. Give a date. Mm. Others. When was it last listed? 27. Okay, get one on date. Okay. Call. Mm. Counsel for the petitioner, Mr. Mm. B.K. Gowai, submits that as per the instructions received by him, the matter has become infructuous. Mr. T.C.S. U.K. Alanet, additional senior government advocate, uh, as well as Mr. D. Bora, Lanet State Council, are present and they agree to the submission. In view of above, the petition is disposed of as infructuous. All right. What is this, interim or a final order? Final order. How many respondents? Two of them. Secretary and Chief Engineer, PHE. Heard Mr. J. Sharma, Lanet Counsel for the petitioner, who submits that the order of this court dated 24/11/2025, passed in WPC number 4080 of 2025, has not been complied with by the respondents, despite a copy of the order having been furnished to them. Next para, issue notice returnable by 4 weeks. Petitioner to take steps for service of notice upon the respondents by speed post within 3 days. List again after 4 weeks. Read. Respondent number 3 and 4. What about 1 and 2? You have not served. Maybe, but have you served them a copy? If you haven't served, notice will go to 3 and 4 only. Heard Mr. D. Rekha, Learned Counsel for the petitioner, who submits that the order of this court dated 11/3/2026, passed in WPC number 1384 of 2026, has not been complied with by the respondents, despite a copy of the same having been furnished to them. Next para, issue notice to respondent numbers 3 and 4 only at this stage. Returnable by 4 weeks. Petitioner to take steps for service of notice upon the respondent numbers 3 and 4 by speed post within 3 days. List again after 4 weeks.
Item 4.
123. 143. You're working as health worker in different hospitals and you are under the management. Then who are the respondents here? These are government hospitals. So direction was to submit their individual representation and they to consider for pay of minimum as per Jagjit Singh. Now the case of Upen Das has been set aside by the Supreme Court. That was in respect of regularization. But here it's regarding the minimum scale of pay. That remains. That remains. Mr. Chaliha, what do you say? So individually you'll examine, they'll file their individual representation. Okay, please write hard, Mr. R.M. Deka, Learned Counsel for the Petitioners, and Mr. A. Chaliha, Learned Standing Counsel, Finance Department. Who else? Anybody else? Finance. Finance Department as well as the Health Department. Stop having regard to the nature of controversy, nature of grievance projected by the petitioners. The writ petition is taken up for disposal at this stage. Next, para, it is the case of the petitioners that they have been engaged on casual basis in different hospital management under the different hospital management societies between the year 2008 to 2015 by various individual orders, and they continue as such on a fixed remuneration. It is the case of the petitioners that they are entitled to the minimum scale of pay in terms of the various decision of the courts. Importantly, the decision of the apex court in State of Punjab versus Jagjit Singh 2017-1 SCC 148, wherein the apex court held that casual employees having worked for considerable number of years on a fixed pay are also entitled to be given the minimum scale of pay like those performing similar nature of work. Stop the learned counsel for the petitioner has drawn the attention of this court to the judgment and order dated 10/11/2022 passed by a coordinate bench of this court in WPC number 7711 of 2016, wherein the court, having regard to the decision of the apex court in Jagjit Singh Supra, had disposed of the writ petition by directing the petitioners therein to file their individual representation before the respondent authority is concerned, and further directed the respondent authorities to consider the same for grant of minimum scale of pay to them within a time frame. Stop. The learned counsel submits, therefore submits that the instant writ petition may be disposed of in similar lines. Mr. A. Chaliha, learned standing counsel, Health and Finance Department, submits that the petitioners concerned should file their respective representations separately, and liberty may be granted to the authorities to consider the same in accordance with the decisions that had been made by this court in the earlier cases. Stop considering the above. The petitions disposed of. By giving liberty to the petitioners to submit their individual representation before the respondent authority. Who? Superintendent who? Joint director. That's what. Before the concerned superintendent of the hospitals in which they are working. Within a period of, you will file representation. Now, within a period of 15 days from today, and the superintendent's concern upon receipt of the same shall place the same before the appointing authority, who shall thereafter consider the case of the petitioners with regard to payment of minimum scale of pay and make due payment if they are entitled to the same. Stop. The decision on the representations to be submitted by the petitioner should be made within a period of 3 months from the date of receipt of the same. Okay. Stop. It is needless to mention here that a copy of the decision to be made should be invariably served to the petitioner's concerned.
Item 6.
Yes. See, just a minute. This is a what? Application for request for deputation to National Museum, New Delhi. You are aggrieved by this. That is what I'm saying. You are aggrieved by this letter. What right do you have to be sent for deputation? Huh? See, this letter is in two parts. One is regarding rejection of the request for deputation. The other one is the observation that you make a proposal to take steps for incorporating a vertical upliftment of the post of assistant architect to deputy architect. What are you at this stage? Assistant architect working in the Directorate of Museum. Architect in museum. Okay. So your case will basically be regarding lack of promotional revenue. See, deputation is not a matter of right, you see. You may ask for it, they may reject it. It in deputation, what is the meaning? It I think it requires it's a tripartite thing. A person has to agree to go. The borrowing department and the lending department has to also agree. Thereafter, then the deputation can be done. And deputation is not for in perpetuity, it's for a particular period, subject to extension or once or twice, whatever it may be. Now, here is a case wherein you say that you are aggrieved by this rejection. How can we help you? The second part, maybe you have there might be a case that you have no provisional, subject to what the other side say. Hmm? Hence, everybody will go out. Since there's no promotional revenue, they'll go down deputation. That is only temporary. You have to come back. Your parent cadre will be your post. Hmm. Supposing your leg is fractured, you're taking painkiller. It's only temporary. It will not cure your fracture unless you have some proper, like put all those plaster of Paris, this, that. It will not cure. Having a painkiller will not cure. Similarly, if you just go for deputation and just, like shut your eyes about your promotional avenues for some time, enjoy 3-4 years there, you're bound to come back again. Then you'll face the same difficulty. So by the time you come back, the flood will reside like that. So what is to be done? This is for motion. We'll issue notice. Infructuous. Uh, 35. These are very minute. How do we read all these things? Mr. Counsel, you must be having super eyesight. These are so miniature. You see, how do we read? Uh, hmm, hmm, hmm. Please read. See, no. The one thing. You just read 60 days from the date of publication of the circular. Doesn't stop there. It doesn't stop there. In the employment news slash Rozgar Samachar. So when was that published? Hmm? Anyway, you respond to this, whatever it may be. We'll issue notice. Hmm. Okay. Anyway, we'll issue notice. But Mr. U.S. Bora, learned counsel for the petitioner, who submits that the grievance of the petitioner is twofold. So firstly, his request for deputation to National Museum, New Delhi has been rejected. And secondly, he does not have any promotional revenue from his current post. Stop. He submits that the petitioner is currently serving as assistant architect in the, what is this? Where? Where are you serving, Mr. Counsel? In the Directorate of Museum, Assam. Stop. The learned counsel submits that lack of promotional avenue being the grievance. The respondent authorities ought to have sent him for deputation as paid for by him. Mr. D. Bora, learned state counsel, on the other hand, submits that a person cannot claim for deputation as a matter of right. And therefore, the contention of the petitioner that the rejection of his prayer for going on deputation being unjustified is misconceived. In this regard, he has cited the decision of the apex court in Kunal Nanda versus Union of India and others. 2000 INSC 235. One is enough, I think. INSC will go for the neutral citation. Be that as it may, since the petitioner has projected that he has no promotional revenue, the matter may be examined. Stop. Accordingly, let notice of motion be issued, returnable by 4 weeks. Mr. So-and-so, London State Council, accepts notice on behalf of all the respondents, and therefore no formal notice is required. Petitioner shall, however, furnish requisite copies of the petition to the Learned State Council within 2 days. List again after 4 weeks. Respondents to file their counter affidavit in the meantime.
Item 8.
Should it remain in the motion stage or we issue notice? That is what I'm saying. Should it remain like this or should we issue notice? Pardon, Mr. AJ Saikia, Learned Counsel for the petitioner, issue notice of motion returnable by 3 weeks. Miss P. Borwa, Learned, you are the standing counsel. NC Hills accepts notice on behalf of the respondents. I think all the respondents. As such notice is complete, petitioner shall, however, furnish requisite copies of the rate petition to Miss so-and-so within 2 days. List again on so-and-so. Disposed. That is in that case. How do we grant the relief in this case? Maybe, Mr. Counsel, please understand. Whatever relief you want in that writ petition has to be passed in that writ petition. We can't pass that relief in this writ petition. Correct? Uh, you file an application for that. It's not your priority. List again on so and so. Date 2 September 2026. Respondents to file their counter affidavit on or before the next day. In the interim, no, the interim order passed earlier shall continue. The interim order passed earlier shall continue to the next date of listing. Mr. Counsel, you file an application. Okay. Your prayer doesn't include all that. You express your difficulty, we'll consider that. Yes, next.
Item 9.
Yes. Mm. Mm. Muster roll. What is your prayer now? Muster roll. Can they get pension? Assam Agriculture University. I think you should file an affidavit. We'll see. That is the order dated 27/2026. Stop today, Mr. S. Sharma, Learned Standing Council, Assam Agriculture University submits that the university being an autonomous body, unless it has adopted the policy regarding grant of regularization to its muster employees, the petitioner cannot claim payment of pensionary benefit as a matter of right. To stop, be that as it may, the matter requires further examination. In view of above, issue notice of motion returnable by 3 weeks. Mr. S. Sharma, Learned Standing Council, Assam Agriculture University accepts notice on behalf of the respondent number 8. Sorry, 678. 678. And Mr. R. Boro, Learned SC AG Assam accepts notice on behalf of respondent number 5. Mr. R. Dhar, Learned Additional Senior Government Advocate accepts notice on behalf of respondent numbers 1 and 4. And Miss N. Hazarika, SC Finance. Oh, okay. N. Hazarika accepts notice on behalf of Mr. P. Naik, SC Finance, representing respondent number 3. Notice is therefore complete. Petitioner to serve requisite copies of the petition to the learned council's appearance for the respondents within 2 days. List again after 3 weeks. Or give a date. List again on 3/9/2026. Respondents to file their response in the meantime. And somewhere you write heard Mr. M.K. Bora for the petitioner.
Item 10,
How much time? Okay. Affidavit is filed by whom? Dima Hazar. Dima Hazar is filed. Dima Hazar. State? Soil? Have you filed any affidavit? But, but, but this is in the motion stage. But they have filed affidavit. Uh, hmm. Okay, what is the prayer? Old pension scheme. Okay, OPS. What is he? He or she? She. He. In your course title, you write Sri wrong, ring Pola. Then in the second course title, you write Srimati. That's why I'm asking you, he or she. Your husband was working as? You're claiming for family. You're claiming for family pension. Oh, you are the one who's serving. Who was serving? Hmm. On what basis? Compassionate. In lieu of your husband. What is the post you're appointed to? What post? Grade 4. Under which establishment? Additional director. That is not, he is not a party also. He's not a party. Principal secretary, then divisional officer is there. Who's working under the additional director? Husband or the wife? Uh, Okay. Thereafter? Okay. That okay, that we'll see. Now question is all right, we'll see that. We'll examine those things. The question which I was putting was where is she working now? Additional director or before the divisional officer or who? Divisional. Okay. Heart Miss, what is a good name? A. Dekha, learned counsel for the petitioner, who submits that the petitioner is currently working under the respondent number 5. No, she's 51 years. What is the age of superannuation? 51. Then you have too many cases to handle. I think you're getting confused. Is currently working under the respondent number 5. uh, on compassionate, no, on respondent number 5. And grievance projected through the instant writ petition is that she should be brought under the ambit of the old pension scheme and not under the new pension scheme. So the learned counsel submits that she has been appointed on compassionate basis after her husband, who was a grade 4 employee, died in harness. Next para, having regard to the claim, matter requires further examination and therefore let notice of motion be issued, returnable by 4 weeks. Who is appearing for the respondents? Mr. Your good name, Mr. P. Hazarika, learned uh, Standing Counsel, Soil Conservation Department, accepts notice on behalf of respondent numbers 1 and 2, and Mr. R.M. Das, learned Standing Counsel, NC Hills, accepts notice on behalf of respondent numbers 3 to 5. Notice is therefore complete. Petitioner to serve requisite copies to the learned counsels appearing today. Stop. It is seen that the respondent NC Hills have already filed their counter affidavit. Therefore, the petitioner will be at liberty to file rejoinder affidavit if so advised. The respondent number 1 and 2 to also file their affidavit in opposition by the next date. This is the matter again on so and so. A date? You want a date or not? Okay, give a date sometime in September. 7 September. All right. The petition, the respondent NC Hills is also given liberty to file an additional affidavit if so advised.
Item 11.
Yes. You're against the de novo proceeding. Is it not possible? Definitely, you will say that. But the thing is that you see, the inquiry officer will submit a report, and the accepting or the authority concerned is not bound to accept that. He may differ also. He may ask for a further investigation or further inquiry. Same book, page number. Yes, same here. Yes. will be communicated to the government servant who shall be also be supplied with a copy of the report of the inquiry held by the disciplinary and a copy of its finding on his charge. Or where the disciplinary authority is not the inquiry authority, a copy of the report of the inquiry authority and a statement of finding of the disciplinary authority. What is so you're saying that this was a shortcut. He did not find agree one moment de novo inquiry. He should have been given a copy of the inquiry report, this agreement. Then what are you supposed to do with that? Okay, show me the order. Page. What are you, circle officer? Uh, Yes. 9.4 is the 9.4 is the initial inquiry. Initial inquiry. Notice given to you, your written statement. I mean, the memorandum of charge, then your written statement, then the inquiry. Okay, now another thing is this is for motion. Last time what happened? This is the second time this stuff. Uh, Notice not yet issued. Huh? Okay, yes. Who is appearing? Yes, yes. The appointed Satyendranath Das is expressed inability. But the decision to hold de novo remains. Correct. So, de no- notification says de novo. Your instruction says from the stage of further inquiry. What is the advice of the PNR? The partner opined either to appoint a new inquiry officer from the seat was left or conduct de novo. No, from the stages regarding the new inquiry officer. No, there are two options. One is from the stage. One is or conduct the de novo. Okay, we'll issue notice. We'll examine. Heard Mr. J. Patwari, learned counsel for the petitioner, who submits that the petitioner is aggrieved with the decision of the respondent authorities concerned to hold a de novo inquiry into the charge levels against him, against the petitioner, against him. Purportedly on the ground that the inquiry report was not found, a query report was submitted in favor of the petitioner and was not acceptable to the disciplinary authority. Referring to Rule 9, capital A of the Assam Services, open bracket, discipline and appeal, close bracket, rules, 1964. The learned counsel submits that the outcome of the inquiry in the form of a report has to be furnished to the delinquent officer along with the disagreement of the disciplinary authority, if any. But in the instant case, instead of doing so, a de novo inquiry has been directed. He therefore submits that the inquiry against the petitioner sought to be made de novo. Being illegal, the same should be set aside. And the petitioner granted the other reliefs as have been paid for in the writ petition. Mr. P. Nayak, learned State Counsel, on instructions, submits that the appointed inquiry officer, through notification dated 13/6/2026, has expressed difficulty to be the inquiry officer, and the department concerned is contemplating Appointment of a new inquiry officer to proceed with the inquiry from the stage which was left by the first inquiry officer. Stop. He therefore submits that, in a sense, it is a continuation of the inquiry and not a de novo inquiry. To support his submission, he has produced a copy of the communication dated 4/8/2026. Made by the Secretary to the Government of Assam Revenue and Disaster Management Department. Stop. However, it is seen that the notification dated 13/6/2026 speaks of holding inquiry de novo. And further, the extension of the suspension of the petitioner has also an abstract of the personal department, which has given two options. That is to appoint a new inquiry officer to proceed from the stage at where it was left, and oblique or to conduct a de novo inquiry. Stop. It therefore appears that whether the inquiry ordered was de novo or otherwise cannot be established without further examination of relevant materials. And therefore, in order to examine the matter, let the notice of motion be issued, returnable by 4 weeks. Mr. P. Naik, Learned State Council, accepts notice on behalf of respondent numbers. All the respondents, and therefore no formal notice would be required. Petitioner to furnish requisite copies of the petition to Mr. P. Naik within 2 days. List again on so and so, huh? Give a date. Interim order passed earlier stands extended till the next date of listing. Respondents to file their response in the meanwhile. Next, in communication dated 4/8/2026. Not required. Let this.
12,
What kind of case is this? Yes, please read. The concept is getting to advance increment. You were given to advance increment or have HSSLC. Then circular was issued on 3/7/2009. That two petitioners. Hmm. Okay, despite this 2018 order, they have still recovered from you. When was it recovered from you? But your synopsis that says that recovery was done in 2006. Long time back. So at the present moment, what is the immediate cause of action? You retired in the year 2024. You must have received your pension by now. Yes, government thing. Will verify. Page number. Mr. Bor Thakur, there are other cases also. What is? Hmm. Hmm. What is there in that? Page 30. Hmm. So just a minute. Okay. All of you have retired. These three cases, all have retired. So I think we can dispose it of in terms of the earlier orders. You will verify and examine, and you are required to file a representation also. Can we dispose it of by a common order, or what is to be done? It's a separate order. See, we'll not narrate so many facts also because not required. Hmm. Okay, please write hard, Mr. S. Botaku, Learned Senior Counsel, assisted by Miss P. Bora for the petitioner. Sub also had Mr. B. Saikia, Learned State Counsel, correspondent numbers 1 to 6. And Mr. S.K. Mehdi, Learned SC AG Assam, correspondent number 8, and Miss N. Hazarika, correspondent number 7. N. Hazarika, SC Finance, huh? Correspondent number 7. Stop having regard to the nature of grievance projected by the petitioner. The same is taken up for disposal at this stage. Stop. It is the case of the petitioner that he is covered by the government circular dated 26/10/1978, by which those having the qualification of HSSLC have been given 2 advance increments. Stop. Although the petitioner had received the advance increment for some time, but later on it was denied to him. Stop. The petitioner contends that similarly situated person persons had approached this court through WPC number 5630 of 2010. And this court, by judgment and order dated 22/5/2018, had allowed the writ petition by coming to a finding that the recovery sought for from the petitioners in respect of the advance increments given to him were not sustainable, as the same was in gross violation of the principles of natural justice. Stop. It was also observed that since the withdrawal of the increment benefit will impact the pay package for the petitioners, the same cannot be retrospectively enforced. And accordingly, the impugned decision to withdraw the advance increments was set aside when and with all legal consequences. The learned senior counsel for the petitioner submits that pursuant to the said decision, the Director General of Police, Special Branch, White DO number 2283 dated 29/9/2018 had allowed withdrawal of two advance increments read like this, dated so and so, had directed that the beneficiaries of two advance increments whose pay has already been modified by reducing the benefit and recovered were accordingly allowed to draw the benefit of the two advance increments. Stop. The learned senior counsel therefore submits that the case of the petitioner is also covered by the state decision. And this can be ascertained from the fact that similarly situated persons, a similarly situated person through WPC number 2373 of 2024 had approached this court against the recovery of the advance increments given to him. And this court wide judgment and order dated 22/1/2025 by referring to and relying upon the previous decision rendered in WPC number 5630 of 2010 had allowed the writ petition. Stop. Paragraph number the relevant observation and direction of this court in the said writ petition may be abstracted hereunder for ready reference. Page 43 and 44. A to A. 43 and 44. So green flag. The learned senior counsel thus submits that the case of the petitioner instant petitioner is also squarely covered by the earlier decision of this court and may be disposed of in similar terms. Learned State Council also submits that the petitioner may submit a representation before the you were under whom? Before the superintendent of police concerned. Others are also Morigaon. Because before the superintendent of police concerned and claiming revision of his pension and pensionary benefits by reckoning the two advance increments. For the needful, as was directed in the earlier petition. Stop. In view of above, the instant writ petition stands disposed of. By directing the petitioner to submit a representation before the superintendent of police concerned, who shall thereafter carry forward the matter in terms of paragraph 16 and 17 as abstracted herein above. Paragraph number 16 and 17 of the judgment and order dated 22/1/2025 passed in WPC number 2373 of 2024 as abstracted herein above. I think that should suffice. Hmm. Hmm. The Learned State Council, somewhere as it given. The petitioner has come belatedly. Since recovery, the petitioner has come belatedly, unlike the petitioner in WPC number 5630 of 2010. And on this ground itself, the petitioner and this ground itself, the petitioner uh, should be rejected. Stop. However, if the court is inclined to consider the claim of the petitioner, the respondent authorities may be given liberty to verify the claim and do the needful. What can we say apart from that? Hmm. Okay. How many items are there? This is 12. 13, no recovery. Twelve is recovery, then 13 and 14, no recovery. 14 also recovery. Okay. 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 You put up with the fine. So 12, 13, 14 disposed.
Item 50.
Also, the petitioner also he participated in the for a post of sericulture demonstrator also. Also 140 posts were notified and they have appointed 125. Two candidates did not appear during the verification process and lots of 13 posts lots of remain unfilled. Lots of one candidate has got lesser mark than me. Lots of may kindly see page 36. That is in the unreserved category. One Lakshmi Soikia. She got 53. And my name Losi will find at page 38. Page 38 also at the top. Sahidur Rahman. His written marks is 54. So admittedly, let's say I got one more than that state candidate. And let's say this 50, if the 15 posts are filled up, I'm in the let's say top of the list. I will get a post, let's say.
Page 38. Where's your name?
Let's say serial number, roll number 0140, Sahidur Rahman. First name.
Page 38.
Page 38, let's say.
Roll number
38.
Roll number 128. Oh,
Let's
sorry.
say 128.
Serial number 128.
120, 0140. I got 54 also. So there are still 15 posts vacant, let's say. They have not verified why these 15 posts have not been filled up, let's say. Also, I also have an interim prayer, Lordship, to keep one post vacant for the petitioner.
But you see the category, it's different, isn't it?
My lord, she is the woman, my lord.
She is a STP candidate, STP plains, but Lordship will come in the right set, Lordship. Unreserved category.
My lord,
Unreserved.
my lord, she is a STP, scheduled tribe plains category, my lord. But she is
was
a woman,
considered.
but my lord, she got into the unreserved category as a woman candidate. Though she is, my lord, she scored 53.
Hmm.
And my lord will see if even 54, the upon that, my lord, 54, 54, 54. These are all women category, my lord.
Where?
In page number 36.
Ah.
Starting from serial number 68, my lord. 1, 2, 3. These are Sumi Mech, Farmina Begum, Priyanka Datta. 54, 54, 54. They secured marks, my lord.
Hmm.
They are, my lord, they come into women category.
Hmm.
There is a, my lord, women reservation also, my lord, in this. And my lord, to start with, now the petitioner is, my lord, alleging that his grievance is that this Lakshmi Saikia 71, she scored 53 and she got a appointment. Did the petitioner make her a party? No, she is not a party. I'm not holding the brief for that particular person, my lord. They have to make her a party first. Number one. Number two, regarding those 15 my lord posts remaining vacant. Those are, my lord, all reserve category post under 100-point roster, my lord, I have a specific instruction from the personnel department, my lord, that those posts cannot be, my lord, filled up. Why, my lord? These are all reserve category posts, my lord, belonging to scheduled trade planes, hills, then FC under the 22%, my lord, reservation category. So we cannot touch those posts. So this is the thing, my lord. My prayer is, my lord will issue notice. We'll file a detailed affidavit in this regard. And let the petitioner make this person a party whom he is alleging.
So I am not claiming,
No, my lord.
I am not claiming anything against Sir Lordship.
No.
I am not aggrieved that he has been appointed.
Then, my lord, this,
I am just
these
giving as a
submission should
citation.
not be made before
I am
this
only
court,
giving a
that
citation.
somebody got up.
Lordship may kindly see page 41, Lordship. Page 41, Lordship. There is a query, Lordship,
No, just a
by the
minute.
director.
I think both of you will submit turn by turn. If both of you submit together, it's difficult to.
Lordship. Page 41, Lordship may kindly see. Lordship.
Total post was how much?
140, Lordship.
140.
Lordship.
And out of which 15 is vacant now.
15 is vacant.
According to you, 15
Lost.
is vacant.
Lordship.
And person who has scored lesser than you has been appointed. Why you have been left out?
Lordship.
And you should be adjusted against that 15 vacant posts.
Lordship.
This is your case.
This is my case. And Lordship, there is a clarification at page 41, Lordship. May kindly see.
41.
Page 41.
Yes, what is it?
This is written by the director to the senior most secretary to the government of Assam regarding 13 numbers of unfilled vacancies of sericulture demonstrator posts out of the total of 140 posts against which written examination was held by Assam State Secondary Education
But
Board.
this is 13 posts.
Lost.
13 or
13
15?
lots, two candidates did not appear during the verification process. Let me complete it. Two candidates did not appear during the verification process. So 13 plus 2, 15.
I see.
Lordship may kindly see with reference to the subject cited above and the recruitment examination for the post of sericulture demonstrators conducted by ASSEB on 26/10/2025. It is to mention that against the total vacancy for which exam was held was 140, while only 127 candidates have been declared. Qualified candidates as received from ASSEB and thereafter 13 number of posts remain unfilled. On the other hand, it is to further inform that 2 number of candidates did not appear for the document verification out of the 127 numbers of qualified candidates that was carried out on 6/1/2026 to 8/1/2026. It is pertinent to mention that few candidates who have secured the pass mark 40 marks as per the government letter under reference and above have now applied for filling up the remaining 13 number of vacant posts from the list of qualified candidates. Further, sir, this matter has also been requested to Secretary ASSEB by letter dated under reference to if any possibility as per norms and region has been submitted for suggestion to. Therefore, you are requested to kindly examine and take up the matter with the personnel department or as deemed fit and suggest whether the remaining vacant post of 15 numbers, 13 not declared plus 2 did not appear for document verification can be filled up from the available list of qualified candidates and as per government rule and procedure. So they have already written to the Lordship Senior Most Secretary to the Government of Assam. Why these 15 posts have not been filled up? So Lordship will issue a notice here, Lordship, and Lordship, one post may be kept vacant for.
My lord may issue notice, my lord, but no interim. Because, my lord, I have a written instruction. What he is referring to, my lord, already, my lord, government has responded to us. This is the document, my lord, I have. They said that these cannot be filled up. Why? Because these are for reserve category candidates under 100 roster point roster, my lord, and the 22% reservation category seats, my lord. So we cannot touch those posts. This will remain because there was no such candidates from this reserve category. So we could not fill it up. But still we cannot fill it up by this unreserved categories. Again, we'll advertise, my lord, and then we'll see, my lord, but we cannot touch it.
What happens then in such kind of situation? It's carried forward.
It's carried forward, my lord. It's a 100-point poster, my lord. It will be carried forward. Because these are reserve category, my lord.
From the list itself,
Or what is the system? I thought perhaps if there was no reserve category candidate who qualifies, there's a fill up from the general.
No, my lord.
But in the next recruitment, it is carried forward in the next recruitment. The posts are filled up.
That is what, my lord, the personnel department has expressed, my lord. I have a written instruction. And, my lord, and the second thing is that the petitioner is alleging that somebody got less mark. And suppose tomorrow the court holds that that yes, this particular candidate got less mark than the writ petitioner, and so the writ petitioner should get that particular post. So my submission is that, my lord, that particular candidate is not a party in this case. Whether, my lord, can this court pass an order behind the back? She has to make a party, my lord, because now they are alleging that she has got 1 mark less than the writ petitioner, and tomorrow, my lord, if we come forward and say, okay, we will forfeit her.
Okay, Mr. Dhar, I've understood your submission. Don't take so much pain.
So, my lord,
Already indicated, I've understood.
my lord,
It is up to him. It is at the risk
No.
of the petitioner.
no, my point is that my lord will record my submission.
Definitely will record it.
My-
Don't
my-
worry.
Lots of-
Anything else to be recorded.
That's all, my lord. That's all.
From the list itself, also it is discernible also how many SC candidate, how many
But
STP
Mr.
candidates. SK Das also.
S.K. Das, learned counsel for the petitioner, which submits that the grievance of the petitioner is that despite having managed to score 54 marks in the recruitment, for the post of sericulture demonstrator, he has been declared to be not qualified. Whereas person scoring lesser mark than him have been selected. Stop in this regard. The learned counsel has drawn the attention of this court to the score of to the written marks of the petitioner at serial number 128 of the list of provisionally qualified candidates. Did I say serial number? Annexed as an extra 5 to the writ petition. He has also drawn the attention of this court to serial number 71 of the same list, wherein the candidate concerned had scored 53 marks but was selected. Stop. The learned counsel further submits that 140 posts were to be filled up. And after the and that there are still 15 vacant posts which has not been filled up. Stop. He therefore submits that pending final consideration of the instant writ petition, one post of sericulture demonstrator may be kept vacant. Next para, Mr. Ardhar, learned
Standing counsel.
standing counsel,
Sericulture.
sericulture department, on the other hand, submits that as per the instructions received by him, the person at serial number 71 of the list not only belongs to the STP category, but is a female candidate. Stop. Although she may have scored 1 mark lesser than the petitioner, but as she belongs to the reserved category, the petitioner cannot have any grievance. Stop. Insofar as the 15 vacant posts is concerned, the Director of Sericulture had written to the senior most secretary of the Handloom, Textiles and Sericulture Department, seeking instruction as to what has to be done. Stop. In response, the government has informed that the 15 vacant posts belong to a reserved category under the 100-point rooster. Oh, you're right. Under the 100 rooster point. And therefore, the same cannot be filled up by any other candidate. By any other by candidates from other category. Stop. He therefore submits that the prayer for keeping one vacant post at this stage may not be accepted by this court. Mr. Ardhar further submits that even otherwise, the petitioner, while alleging that a person with lower marks has been selected to the post, has failed to make that person a party respondent to the instant proceeding. And therefore, the petitioner, and therefore the writ petition on this ground would not be maintainable. Next para, having regard to the above projection, further examination of the matter would be necessary, and for which let a notice of motion be issued. We'll have a short date,
I will file an affidavit, my lord.
returnable by so and so, give a date. Mr. Ardhar, Lanet Standing Council, Sericulture, accepts notice on behalf of respondent numbers.
My
One,
lord, can you do 3 weeks, my lord? I will file affidavit. We get instruction and
okay,
then always come and.
you'll be for 1 and 2.
My lord, 1 and 2, my lord.
Number 3 is what? School education.
School education.
Why?
Because they are conducting the exam, my lord. This exam.
Spot number 1 and 2. Well, Mr. DK Roy, Lanet SC, ASSEB, accept notice on behalf of respondent.
Lordship, on the next day, they should also clarify the roster reservation, Lordship. Now they are saying that the posts have been exhausted. There are sufficient, Lordship, candidates from SC and STP who have been appointed.
I never said
And
exhaustion.
women candidates have also been appointed. 30% women reservation.
Returnable date.
So Lordship will indicate that roster reservation will also place before the honorable court, Lordship.
They will file affidavit itself, so that will indicate.
We'll file affidavit, my lord.
If your Lordship indicates that, Lordship, that
I never said exhausted, my lord. There are no candidates who could not exhaust it. On the contrary, my lord.
The respondents to file their contract affidavit on or before the next date.
Lordship, given a fixed date, Lordship.
Yes. 26 days.
Lordship.
Clear, please. Lordship, my father was working as a grade 4 employee under the office of the Election Commission in the district of Lakhimpur. Then thereafter, he got superannuation from his services that is 28th February 2018. Accordingly, he got a retirement benefit and he also receiving pensionary benefit, having PPO number so and so. But in the meantime, he passed away, that is on 29 to 2024. Accordingly, being an unmarried daughter, I have applied pensionary benefit before the authority, but authority has not released pensionary benefit to me, Your Lordship.
Where is your approach?
On basis, yes, my application, Lordship. Prior to filing my application, Lordship, I have approached before the authority, but application annexer H, page number 30, Lordship.
This was only in July.
Yes,
There's
Lordship,
no time to
prior
react.
to my application, Lordship, I have repeatedly approached before the authority, Lordship, for granting me pensionary benefit. Even after Lordship, authority has denied to receive my application, Lordship.
And
Being
where's your statement to them?
Lordship, on basis of my Lordship.
Statement. Your statement,
Yes, Lordship.
your oral submission will not do.
No, yeah, absolutely not. So. That is paragraph number 10, Lordship.
What does it mean? Again and again you approach, and secondly, your mother has remarried.
When we were
Your
minor,
mother's
Lordship,
remarried. And what about your brother?
my brother is with me, Lordship, but he is major. Therefore, he is not entitled to get pensionary benefit.
Mother has remarried.
No, my mother is still now alive, but when we were minor, Lordship, in existence of my father, Lordship, he elopes with someone else, Lordship. When we were minor, at the age of we were 6, 7 age, Lordship.
Okay,
At that time.
after retirement, your father was enjoying the pension.
Yes,
He expired.
yes,
Thereafter pension stopped.
yes.
You
That
are the unmarried daughter.
No,
So-
I am unmarried daughter. Being an unmarried daughter,
That's what I'm saying. You are an unmarried daughter. That's
Yes.
why you are entitled to that.
Yes, on basis of the government notification, Your
Will
Lordship.
issue notice what is there to be done at this stage.
Yes.
My lord, because
Art,
I
Mr.
don't know, my lord, what is the story on the other side.
Art Mr.
M. Soikia, Lord.
M. Saikia, learned counsel for the petitioner, who submits that the grievance of the petitioner is that despite repeated request made by the petitioner and also a representation submitted with regard to payment of family pension, on account of being an unmarried daughter, the respondent authorities have failed to consider the same and grant the relief. And therefore, the petitioner is before this court. The learned counsel submits that the petitioner is entitled to receive family pension, being an unmarried daughter, and who was dependent on her father. In view of the amendment of Rule 143 of the Assam Pension Service Rules. In view of above, issue notice of motion returnable by 3 weeks. Mr. Ardhar, learned. This is department or
No, my lord, as an addition of senior, my lord, 3, 5 and 6.
additional senior government advocate, accept notice on behalf of respondent numbers 3, 5 and 6. Mr. R. Boro, SC, AGSM. Accept notice on behalf of respondent number 4. This A protocol, SC penance accepts notice on behalf of respondent number 2. And what is this? Election Commission?
State Election Commission, my lord. State election, Rakesh Dubey, he generally appears, my lord. He is a standing counsel. R. Dubey.
R. Dubey.
Yes.
We'll record his name. Give him a copy.
Lordship, I will give him copy, Lordship.
Mr. R. Dubey, Learned Counsel, Learned SC, Assam State Election Commission accepts notice on behalf of respondent number 1. Then what about 7? Election Commission in the District of Lakhimpur.
District Commissioner will represent.
No, no, my lord. It is in the capacity of election, so Rakesh Dubey will appear. I am appearing for district commissioner.
Okay, R. Dubey will be for 1 and 7, okay? 1 and 7.
Election commission হয়ে গেলে একটু election আর আমরা করবো।
We'll make it 4 weeks instead. Returnable 4 weeks. List again after 4 weeks. Respondents to file their counter affidavit in the meantime.
People.
May I please, your lordship? Lordship, I am for the petitioner and similar 5 matters have been fixed on 10th of this month. Similar matters. But only the difference, it differs. The instant writ petition differs from those because those 5 remaining matters have been adjudicated and dismissed by even by the Honorable Apex Court and as well as Division Bench as well as Single Bench of our court. But this matter was dismissed by the previous single bench of this honorable court. Thereafter, I preferred before the division court, division bench, and subsequently it was withdrawn with liberty. Now, what is the difference between this one? The instant case was not dismissed by the honorable apex court. And what are the difference? Because I was rendering my service for a couple of years, more than 10 years, lordship, I being the 51 years lady. What is the difference between SW of the post SW and LDA? LDA is official post, SW is that is field works. Now, I being the married lady, I am suffering from a lot of that is illness, have been medically operated. So at this stage, I have been reverted back to the SW, to my original post, without serving any prior show cause notice. Now, honorable, lot of judgments are there by Honorable High Court or High Court in writ petition number 4849/2022. Hemanta Changmai versus State of Assam and others decided on 28/11/2024 says, once I have been promoted, para 7, in that judgment, it is said, once I was promoted to the post of UDA from the post of LDA, subsequently, without any prior notice, show cause notice, I was reverted back to LDA from UDA.
Where is your reversion order?
Reversion order, lordship,
Page 44.
page 44, annexure 4, lordship. Here also, against that I replied, kindly see page number 47, lordship, annexure 6. Para 3 of my representation, I have specifically mentioned, lordship, for long duration of length of my service, neither I was promoted nor I was extended any higher post. Now at this juncture, when I was reverted back, I was accommodated to SW to LDA. Now at this juncture, without extending any opportunity of promotion, when I was reverted back without any show cause notice, that is not tenable in the eye of law. As per the Asraful Ali Sharma versus UPSTR C 1994, 3 LLG supplementary 384 all.
But you see the reference in the speaking order.
Speaking order, I will place it in course of time before your
Serial number
lordship.
1, 2, 3 is there. This is the reason. Yes.
Lordship. At this juncture, I may kindly be protected by your lordship, as because let them reply,
The
lordship.
petitioner was originally appointed as SW,
SW exactly.
surveillance worker. So
May-
for some purpose,
Let me complete.
yes.
with due consent of this honorable lordship.
The matter is coming
Lordship,
up on
kindly
tenth,
see.
Mr. Council, tenth.
Lordship,
The other matters are coming on tenth.
10th lordship.
They'll come up on tenth.
Lordship, only my humble
I think
submission
it's the
is
same
that
thing.
kindly see page 37 or 39. This honorable court passed stay the operation of the impugned order in my earlier petition. So kindly protect me, at least till till 10. Till 10. It may kindly be.
Been done, my lord.
Till 10,
A
lordship.
read petition has
Because
been
this is quite
dismissed
different.
and
No, no,
the
read petition.
substantive post is SW, my lord.
Lordship, two things are there. One is, had I been accommodated to the same post, that without prior notice I have been reverted, that is not supported by writ petition number 4849 of 2000, already decided by this honorable court. Justice Shuman Sham, dated 28/11/2024 in Hemanta Changmai versus State of Assam and others. It was this para number 7. And if it is promoted, it is from SW to LDA. If it is a question of promotion, then that is not supported because I was I was extended 6,200 rupees right now. To the post of LDA, I have been extended 6,200 great pay. When I'll be reverted back to SW, I'll be extending 5,600. Obviously, my great pay will be affected. So this is a fit case in the eye of law, lordship, to be stayed the impugned order.
But what can we do? Division bench has held.
No,
Yes,
I have
confirm.
withdrawn that one.
Division bench has.
No, in other
Supreme Court.
cases.
In other cases,
You're not a case of,
not a case, exactly.
you cannot take your case in isolation.
Lords,
A bunch of cases have come up.
lords.
Division bench has upheld,
And
rightly or wrongly.
Supreme
It
Court
it
has
was
also-
tested before the Supreme Court. Supreme Court said nothing doing.
Lordship.
Now you
They
can
could
come back and say that
other petitioners didn't come out with flying colors.
you take it on Monday or I'm just issuing notice. That's all. No
Issue
stay.
notice, lordship, kindly.
Heard Mr. JP Das.
JP Das, lord.
Learned counsel for the petitioner. It submits that the petitioner is agreed with the issuance of the speaking order dated, what is that? Page,
Page 44, lordship.
Dated 9/6/2025, 26, my lord.
page 44.
44, lordship, annexure 4. Dated 9/6,
Speaking of-
2026.
Speaking order dated 9/6/2026. By which the petition has been reverted from the post of LDA to that of surveillance worker without affording or any opportunity. It is however seen that the said speaking order has been issued pursuant to the decision of a cornet bench of this court, the writ appellate court as well as the apex court. As can be seen from the speaking order itself. Be that as it may, the contention of the petitioner be examined and for which let notice be issued, returnable by 4 weeks.
Lordship.
Mr. Bora.
Yes, my lord. I appeared for response number 1, 2, 3, and 4, my lord.
Except notice we have responded 1, 2, 3, 2. Then
And sorry, 5 and 7.
M. Hazarika. Learned concept is for except notice on behalf of respondents 5 and 7. Then
5, 7, and 8. Finance department.
5, 7, and 8. Finance, isn't it?
Yes.
But 6 is by name.
Yes.
One is
6 is by name. Why?
because he is a colleague and he has been promoted to a higher post. And till date, yes, private respondent. The official one, not official respondent is private Tariq, I think.
The grievance against response number 6 is that, my lord, till that he has not been reverted.
Lordship,
That is the
he was.
But why should you make him a party like?
Yes, Lordship, because he was also appointed as SW, wherein I was also appointed. Subsequently, along with us, along with me, he was also reverted back. to
Maybe, but
LK.
that doesn't mean that you have to array me as a party.
That is Article 14 and 16 has been violated, Lordship.
You want him to come and support you.
No, because he has.
He will file counter affidavit against you.
Yes.
Instead-
Let him reply, Lordship.
No, I don't see why he should be made a party.
Because he was also appointed in the same post where I was. There
Are you seeking any relief from him?
no,
that is
because
the issue.
discretion have been made.
No notice is required to be issued on respondent number 6 at this stage. List again after 4 weeks. Obliged.
Lordship, highly obliged.
How many years remaining now? We are done 17. Starting from 18.
Obliged.
Okay. May I please, Your Lordship. Lordship, the petitioner has challenged rejection of his candidature due to non-production of OBC NCL certificate within 14 days 10/2024, which is the deadline prescribed by the advertisement. Same case. Same case, but he has a certificate within the 6 months period because there is a notification dated 17/8/2017, which states that there was some similar matter was taken up the other day. Yes. What did we do? Lordship, I
Lordship,
fixed this
here,
matter
Lordship,
along with
kindly
those
see,
matters.
page 94. The rejection order.
Hmm.
Any other discrepancy notice specify the date of birth, so and so, 20 OBC non-creamy layer certificate as on date, so and so, not produced, due to which you are overage and not eligible. And he had now produced that certificate of NCL. At that point of time, whether he produced this or not, Lordship, I have to take the instruction to that.
That certificate.
Otherwise, if according to 2017, it is a covered case that he had the certificate before the prescribed period.
Was that 17? Have you annexed it?
17
95. Page 95. Important notice. Yes.
Otherwise, he. This is
What is your instruction? Have you produced? Lordship. Because the certificate, in fact, which the reason of unfitness was that he could not produce a certificate as on 14/10/2024. He has the certificate that your Lordship will find at page number 20. It dated 6/1/2025. So that is within the 6 months period as prescribed. Page number 20. The OBC NCL certificate. 6/1/2025. That is within the 6 months period as per the notification dated 17/8/2017. So his rejection was because he failed to submit the certificate which should have been issued as on 14/10/2024. That is what the rejection order speaks. That's okay, but what did you produce? Lordship, these two certificates, page number 19 and page number 20.
Lordship, this was rejection was of 2/12/25, and this 2017 certificate came into order in terms of that last order, Lordship, here next. It was come 7/4/26. Thereafter, this notification, it was prior to that, but it was came to knowledge of our Lordship thereafter, Lordship. This 17 notification, Lordship. Because it was for a specific, this was for a specific year, but after taking instruction, we have come to that this notification still hold the field. And in terms of that advertisement, it was no mention where is there about this.
Regarding the notification.
Regarding the note. That's why, Lordship, it has been rejected by that 2/12/25 notification.
And in
Let me
fact,
have the instruction, Lordship, on that.
on the basis
whether
of the
he-
instruction, coordinate bench of this honorable court has already disposed writ petition number 555 of. How was it disposed? Lordship? That your Lordship will
Because
find page number 98 to 101. That is on the
In-
basis of the instruction produced by my learned senior friend. And the writ petition was disposed of. There also, the candidate failed to submit the OBC NCL certificate, which was required to be issued on or before 14/10/2024. So there his certificate. It was belated production, correct? Yes. Now, thing is that my query was, as on the time of application, did you submit any sort of testimonial saying that you belong to this.
Lordship, at the time of filling up the online application, we are not required to submit any documents. We are just required to click the
Declaration.
Declaration.
yes.
Declaration.
I see.
At that time of document verification, they have to.
We are
produce it.
required to
And
produce.
verification happened when?
On
The
2/12/2025.
rejection was of 2/12.
2/12.
Yes, on that particular day, the document
And
verification. has
online
taken
was
place.
on which date?
Online was prior to 14/10/24.
I see.
14/10/20. The last date of application.
So this important notice clinches the matter, then what is there to take instructions?
Lordship, at that point of time, whether that is the,
When you say that he is not required to physically or online, like submit the certificate itself, only a declaration that you belong to this. So the office important notice gives 6 months.
Yes,
this was not reflected in the advertisement, Lordship. This
May not,
noti-
maybe, but we have considered similar cases.
Lordship.
So in line with those, we can dispose it of, I think.
Lordship, now let me have whether the vacancy, because results were declared in 26, Lordship. That's why, Lordship, I have to take some instructions, Lordship.
Okay, heard, Mr. B. Arbora, Lordship, learned counsel for the petitioner who submits that the petitioner is aggrieved with the rejection of his candidature for the post of constable bracket GD in the what is that?
Constable
APF.
CAPF, Lordship. May I just humbly
CAPF.
submit before your Lordship passes the order?
Sorry?
May I humbly submit before your Lordship passes the order? In respect of the instruction which my learned senior friend wants to place, Lordship, the recruitment authority is still continuing the process because they are, your Lordship, on that particular day, on day after, day before your Lordship, on, I forgot the date. On last week, your Lordship had taken up a repetition, Rajesh Chaudhary. Therein, similar case was there in terms of where his NCL certificate, he failed to submit the NCL certificate, and therefore this honorable court directed in terms of the notification, and then he was medically examined just 2 weeks ago. So therefore, they are still continuing the process.
I have to take the instruction to that, Lordship.
Short date, take a short date.
Lordship.
Yes.
What is the last line? No, CAPF. Central Armed Police Force, CAPF. And others, huh? On the ground that the petitioner had submitted belatedly the OBC and non-creamy layer certificate. Top, in other words, the said certificate was not submitted as on 14/10/2024. And therefore, his candidature was rejected. Since he became of age without age relaxation given to the reserved category. The learned counsel otherwise submits that case of the petitioner is otherwise covered by the, within inverted comma, important notice, close inverted, dated 17/8/2017, bracket annexure E, issued by the Staff Selection Commission, by which such certificate can be produced up to 180 days after the closing date of the application. Stop, since the important notice is applicable to the case of the petitioner. The rejection of the candidature of the petitioner should be interfered with by the school. And he be allowed to take the review medical examination, review medical,
Lordship?
review medical.
No, Lordship, it is for NCL certificate.
No, once your lordship interferes with the rejection, he will be undergone detailed medical examination.
DME.
Be allowed to undertake the detailed medical examination. The learned counsel has also submitted that similar order had been passed. No, submits that the relief has been granted by this court in a similar case. That is WPC number 555 of 2026. Bracket Sri Chandan Chauhan versus Union of India and others. It is a next step as an extra F to the instant writ petition. The learned counsel also submits that the recruitment process is still in the process. It is still in progress. And therefore, direction can be given by this court. And therefore, appropriate direction can be given by this court. Stop, Mr. S.S. Roy, learned CGC. However, submits that he may be given a short time to take instructions in the matter. Accordingly, this is the matter when
Lordship
week?
on 18th.
on 18th of August. Not
Lordship.
in the motion column.
Obliged.
May I please, your lordship? May I please?
Yes,
Lordship, this is a case, lordship, for non-payment of just amount of rupees 50 lakhs to the next of kin of the one late Komal Das. Milord. Lordship, as
what
per
is
the
this amount regarding?
50 lakhs,
What is this amount? Ex gratia?
ex gratia.
Well, this is basically a bench 5 matter. Bench 5, not bench 3. Ex gratia payment by some maybe default has come here in this bench.
It is submitted at the bar that the matter is a bench 5 matter. Registry to verify and list accordingly before the appropriate bench.
Payment of ex gratia is taken up by bench 5.
Okay.
Right.
May it please your lord.
Yes,
While the petitioner was serving as the senior food safety officer,
senior
food safety officer
food safety.
under the Health and Family Welfare Department, and an allegation was brought regarding his unauthorized foreign visit and disproportionate assets. Accordingly, a so-called notice was issued, a disciplinary proceeding was conducted, and he was punished with a withholding of one increment. Again, on the same, my lord, allegation of disproportionate asset, a second inquiry was conducted, which culminated into dismissal from service. Now, my lord, they have not submitted me the inquiry reports and 2-3 other documents. I want to assail the dismissal order. I have written to the authorities, please furnish me the entire documents so that I can avail my legal remedies. But they are not submitting the required documents. That's why I'm before this honorable court. Also, will kindly direct them to, because they are a welfare state, my lord, and I am intending to avail my legal remedies.
But what about the RTI and all that?
I have represented, filed an RTI and as per the 1964 rules, a departmental appeal has to be filed within 90 days, 3 months. Already 2 months have elapsed, my lord. So it will frustrate my cause. That's why they have to furnish me the documents. As per Rule 17 of the 1964 rules, a departmental appeal against the dismissal order has to be filed within 3 months.
So on what basis are you filing this writ petition?
Because, my lord,
There's no order in your hand. We don't know what has happened to you.
no, dismissal order I have.
You have the dismissal. Where's that?
Lordship will kindly turn to page 16,
16.
16. The enquiry report and other documents, they are not furnishing. At page 17.
But you don't dispute the fact that there was an inquiry.
No,
Otherwise,
I don't dispute. I
you
want,
participated also.
yes. Now I want to avail my legal remedies against this dismissal order. At page 17, penultimate para, the dismissal order is there.
On what ground you want to challenge this?
I want to challenge it because already I was penalized on the same set of charges, my lord. The earlier penalty order starts at, my lord, page 14. There cannot be two disciplinary proceedings, my lord. Page 14 is the earlier order.
What is the withholding of increment?
Yes.
What was the charge?
Charge was unauthorized foreign visit and disproportionate assets, my lord.
Where do you get that?
My lord, at page 14, the earlier penalty order starts.
No, that misconduct. of-
Second para, my lord, second para, page 14.
Accused of amassing assets which is disproportionate to his known source of income.
Yes,
Committing offense of criminal misconduct and
Uh,
abusing official position.
yes. So this order was issued on 30/10/2023. Now, Lordship will come to the next at page 16, the new penalty order. Page 16.
Anything mentioned about the previous order?
Nothing, my lord. So here I'm not assailing this, my lord. I want to assail because I need the documents. At prayer A at page 11, I have stated what are the documents I have sought that they have not given. Page 11, prayer A, capital A.
11.
Page 11, capital A prayer, my lord. These are the documents I want.
Your reply should have been with you.
Yes, two documents I have misplaced. I have stated that.
They heard Mr. J. Patwari, learned counsel for the petitioner. To submit that the petition is agreed with the include order dated 12/6/2026, bracket annexure 2, by which he has been dismissed from service.
The same allegation.
Despite the fact that, continue, huh? Not full stop. He has already been same charge. Invite order dated 30/10/2023, bracket annexure 1. Learned counsel submits that the petitioner was working as senior food safety officer
Yes.
in Lakhimpur at the relevant time. And a disciplinary proceeding was drawn against him for disproportionate income.
And at para 1, my lord, at page 15, unauthorized foreign visits. Para 1 of page 14. The first penalty order.
Besides visiting foreign countries several times without government approval. The learned counsel submits that despite several requests made by the petitioner, the relevant documents sought by him has not been provided to him. And therefore, the learned counsel submits that the respondent authorities may be directed to furnish the relevant documents such as show cause notice dated 18/4/2022, comma, petitioner's reply dated 5/5/2022, comma, the inquiry report dated 23/9/2022. And the subsequent inquiry report dated 22/3/2024. Submitted pursuant to the fresh show cause notice dated 18/12/2023. View of above, issue notice, motion with returnable by 4 weeks. Miss. Yes, you are appearing for
I'm for health department. That's all.
which department? Health.
Health department.
What is your good name?
B. Bora on behalf of Mr. D. Upamanya.
Ms. B. Bora, learned counsel appears on behalf of Mr.
D. Upamanya.
D. Upamanya, SC Health Department. Who represents respondent number? Who will represent respondent number 1, 2? All the
All the
respondents.
respondents.
Notice is therefore complete. Petitioner shall however furnish requisite copies to the learned standing counsel health within 2 days. List again on so and so.
Can it be a little earlier, my lord, because my limitation period would be over, my lord. They have to just furnish me the documents. There is no dispute, my lord. This is not an adversarial litigation.
Give a date,
Next week, my lord, if possible.
not next week, I think. 24/8. Pendency of the writ petition will not be a bar for the respondents to furnish the petitioner the documents which he has sought.
Deeply obliged.
May will also valid. This is one of the classic cases of an harassment by the employee to the employee. My lord, you also had the occasion to deal with this case once in 2025 perhaps, where your lordship had issued notice and granted stay. Now, my lord, what happened? The petitioner here is under suspension, and he had applied to come to Guwahati for appearing as witness in the Bar Council of Assam, because there is a complaint against one of the employee of the institute, my lord, and he had made the complaint, my lord, against my friend here, and he sought for permission. There was no reply, nothing. It Annex 11, page 72, as well as, my lord, yet Annex 8, page 63. They remain silent. But he had to come because it is judicial, quasi-judicial authority, Bar Council of Assam. So he came and gave the evidence here, the evidence chief, against that employee. Now, my lord, he has been charged with leaving the station without leave, without permission. Being under suspension, you have left there. There is charge. And how the charge is given, my lord, you will also kindly see. Annexer 12, page 73. The director is acting as if he is the governor of Assam. And once the one court manager caught him. Are you governor? That he rule says, my lord, that he is to initiate the person himself. He cannot delegate the power, nor he can say that on the approval of the director. 73, my lord.
What have you challenged here?
That initiation of charges and proceedings.
Page number?
73.
73.
Huh?
You will also want to see the memorandum of charge. Before that, the forwarding report.
There is no index to your writ petition.
Yes, my lord, the lengthy index.
Where's it? Okay. Page number, impugn order is at page
Yes, yes,
73.
73, 73, 83. Annex 12. Your lordship, see the page 70, 74. 74 last page, of the forwarding report. This is issued as per approval of the director. It cannot be managed. This very basis, lordship on another case against this employee only, the lordship state the order. You should notice that is pending. That case is pending, still pending. Because I have annexed the minor constitution of the institute minor, and that said that under clause 23, article 23, the director himself has to initiate the proceeding. Neither he can delegate, nor he can authorize anybody else to initiate the proceeding. So this is totally against their own rule in the constitution.
Who is the appointing authority?
Appointing authority is minor here, the director.
Director.
Yes. That's why, my lord, I've also annexed, my lord, the constitution also.
Page 33. Constitution.
Article 23,
Okay.
annexer
Tell me the
Two.
page number.
Annexer 2,
Page
page
number,
32.
32.
relevant portion.
There portion, article 20, just a minute.
39, my.
Yes.
Plus
23 yellows only. Power of director to delegate. The director may delegate any of his duties, function and power to any officer of the institute with the previous approval of the council. There was no previous approval, nothing. So this charge itself fails, my lord. And that too, here the initiative.
No, anything on the appointing authority? Who is the appointing authority?
Appointing authority, my lord.
Any document?
See,
Any document?
appointing authority is, my lord, director.
Is there any document to show that? Director is the appointing authority. Yes, what
The
is it?
Constitution is there, my lord. The employees of the institute is used to the appointed the employees of the institute. Director has the power.
Direct.
And delegation of power, so far as is allegation, my senior's allegation that whether the memorandum is valid or not, legally valid or not.
Which memorandum?
My
Charge
lord,
sheet.
Oh, the charge.
power that previous,
See, the simple issue at this stage is, according to the petitioner's counsel, the memorandum is not sustainable because it has been issued by an officer,
subordinate officer.
subordinate officer, not the appointing authority or the disciplinary authority. Subordinate to the appointing authority. Subordinate to the appointing authority. Article 311 Constitution.
My lord,
But this page 39 says that director can delegate.
yes.
Delegate.
So whether there is any delegation or not,
By the council, he must authorize.
He has delegated his power to, after approval, the memorandum.
where is that?
Yes.
Where has he delegated? Any document?
No documents, my
Then
lord.
you obtain
It is the-
instructions.
My lord, the power,
You obtain instructions. What can you say now?
the EC. Second is, agenda.
What?
Agenda, my lord. Agenda number 7, my lord. Second by the EC. Agenda number 7, my lord.
Yes, so what is the relevant thing?
Another, my lord,
No, there is no delegation to direct matter here. It is not required to be discussed in the council meeting, my lord. Nothing but no concrete,
My lord,
my lord, resolution taken for delegation to director.
the government issued this letter to the director that uh, directing the authority to implement the decision taken in the executive council meeting and board of governors meeting regarding change of constitution. Implement that executive council already taken resolved the agenda that it need not. He has the prerogative to delegate his power to any subordinate officer.
Where is that?
That is-
Agenda number
that
agenda number 7 says, my lord, the executive council is of the opinion that formation of the department committee and delegation of powers of the various officers of the institute is a prerogative of the director or of the institute, and these matters is not required to be discussed in the, what is the resolution delegating him? Here must the resolution, because Article 23 says so. Any officer with the of the institute with the previous approval of the council.
We shall file an affidavit, my lord, in this regard, we should notice, my lord, annexing all these documents, approval of the.
No, that is what I thought. So, but you're giving me paper after paper. What is this? Minutes? What is the relevancy here? Tell me.
Agenda number 7, he has got the, director has got the authority.
He has got the authority, but where has he delegated it?
It-
He has to delegate to the officer concerned.
Yes.
Now, the memorandum has been issued by whom? By administrative officer.
Yes.
my lord.
Where is the document wherein the director has delegated the power to the administrative
It is
officer?
motion stage, my lord.
That's why I
Don't-
told you in the beginning that
don't have
you will have to get instructions.
take instruction.
You are
my lord.
producing one paper after the other and doesn't make any. Part Mr. R.P. Sharma, learned senior counsel, assisted by Ms. M. Das for the petitioner. To submit that the petitioner is agreed with the memorandum dated 13/7/2026, bracket annexure 12, by which the petitioner, who is a staff nurse,
Nurse.
huh?
Nurse.
Staff nurse.
Yes.
That's what. The petitioner who is a staff nurse in the LGB Regional Institute of Mental Health,
He is presently under suspension.
Tezpur, Assam. Has been issued the memorandum of charge signed by an officer who is below the rank of the appointing authority. Is there any suspension?
Yes, my lord.
Where?
He has been suspended, my lord. He is under suspension.
Where is the suspension order?
Suspension order, my lord, just a minute. Order of suspension is.
Now, he therefore submits that the impugned memorandum is non-est in law, as it strikes at the very root of Article 311 of the Constitution of India. Most of the learned senior counsel submits that although there is a provision for delegation of powers to the by the director, as per clause 23 of the Constitution and bylaws of LGB Regional Institute of Mental Health, Tezpur. But there is no material to show that such delegation has been done. And the administrative officer,
He is not even administrative member, he is in charge only. He is far junior.
the administrative officer in charge has been delegated such power to issue the memorandum of charge. Next, parent due for above, issue notice of motion returnable by. How soon can you get the instructions?
My lord,
Issue,
we have
3
to
weeks.
file this, while the affidavit of opposition, my lord. So 2 weeks, my lord.
done over by 2 weeks. Mr.
Okay, doctor.
A.K. Datta, Learned Standing Council, Health,
Standing council of the
I'm
institute
sorry,
and
Standing Council of the
institute,
Institute
CGC, my lord.
and also CGC,
Yes.
accept notice on behalf of
All the respondents.
all the respondents and therefore formal and therefore notice is complete. Petitioner shall however furnish requisite copies of the writ petition to the learned CGC within 2 days. List again after 3 weeks.
Date may be fixed.
Interim order nahi pura.
Hmm?
Interim order.
Interim order, my lord, it is a preliminary memorandum, my lord.
No, no, it is final.
It is not asking for reply the.
Mr. Sharma, you have not prayed for any interim.
Madam,
It's a, if you have come to your prayer portion, there is no prayer for interim.
junior sounds.
List again on so give a date.
Yes, one, there is.
Where?
Page 16, madam. Number so and so. Issued by respondent number 7 and pending final decision of the repetition, stay suspend further proceeding pursuant to the improvement memorandum dated 13/17/2026. Here's our report, madam.
As your lordship, please, my lord.
In the,
Because-
having regard to the projection made, the status quo is on date shall be maintained.
Mr. Go, my lord.
Status quo
Till next day.
till the next date of listing, yes. Yes,
May I please, Lordship?
you're expecting somebody to come
Lordship, I was expecting he was sitting here only.
to respondent side.
Respondent.
Who's that? Arunachal,
Lordship, yes.
G. Arunachal.
No.
I'm representing respondent number 1.
Union of India.
Oh, Union of India, sorry.
Lordship. Lordship, the matter relates to an arbitrary, malified and malicious transfer involving a young 28-year-old girl from Northeast. She is working in a PSU, THDC India Limited, under the Union of India. What is shocking and disturbing is that the transfer is in violation of the company's own guidelines. It has been done primarily on account of her gender and the place she belongs to. And thirdly, she is being targeted and not other similarly situated employees. And fourthly, there has been a series of acts of continuous harassment and malified and malicious actions, particularly by respondents number 5 and 6. Lordship, the present writ petition challenges the order dated 30/07/2026. I'll draw your attention to Annexure 3 at page 59. Passed by Shri A.N. Tripathi, who is the respondent number 3 in the instant case, pursuant to the judgment and order dated 24/06/2026, passed by this Honorable Gauhati High Court in WPC 307 of 2026. Lordship, may I read out the relevant portion of the order?
You're aggrieved by the speaking order
Lordship,
at page 60.
Lordship,
Is it page 60 or 60? 60.
Lordship. Now, Lordship,
Yes, where the High Court judgment?
Lordship, Lordship, I'll read out. Lordship, I'll take up the Lordship, coming to page 50, Lordship. That is the judgment of this Honorable High Court. Para 9. Para 9. Considering the issues and facts placed before this court is of the considered view that the respondents, being a PSU, are conscious of the hardships and difficulties faced by their employees. Therefore, it would be in the interest of justice if the petitioner is permitted to ventilate her grievances before the responding authorities by filing a fresh representation. In the event the writ petitioner doing so, which we have done, the respondent authorities will sympathetically consider these grievances as may be urged in the representation and thereafter pass appropriate orders. While disposing of the representation, the respondent authority will also take into consideration the fact that the petitioner is a lady employee and therefore necessary considerations in respect of such lady employees shall be duly taken into account before passing the order by the appropriate authority. Lordship, in para 10, the last line, therefore, thereafter, the respondent authorities will consider the matter in its entirety, including, and specifically it is given, including the transfer and posting policy, and pass a reasoned and speaking order. They have not considered this transfer and posting policy. Para 11, before last line, before such an order is passed, the petitioner may be given right of personal hearing if she so desires. I have been denied that right of a personal hearing. Lordship, despite the judicial guidance, judicial mandate and directions from the Honorable Court, which of course implies heightened obligations and responsibilities upon the respondents, the proprietary has been thrown to the winds by the respondents and my representation has been rejected and the premature transfer order has been reaffirmed without giving me an opportunity of personal hearing.
By this order dated 37/26.
Lordship, Lordship, I would also draw your attention.
Where are you now? Where are you?
Lordship, I would also draw your attention to the company's transfer guidelines at page 74, Lordship, para 6. Page 74.
5 years.
Yes, Lordship.
Transfer after 5 years in a station.
Yes.
You've been posted there in 24.
I have been
You
posted.
have not completed 5 years.
I've just completed 2 years and Lordship, if
Yes.
I may be permitted. Para 6.1 says 5 years for executives. 6.2 says will be considered after they have spent a minimum period of 5 years at one location. I have just completed 2 years. And para 6.3, where they are saying that there is that the recipient department wants her at Rishikesh, here it is specifically given that criticality at page 75, Lordship. Page 75.
Yes, yes.
Criticality of manpower for the donor and the recipient department project office employees will be considered for transfer after they have spent a minimum tenure specified in clause 6.1 of the guidelines, which is 5 years. That means I should have been considered, even if someone says, yes, it is wanted. But the same has not been done. Beg to mention that, Lordship, as far as the transfer order is concerned, Lordship, that is at page 69, Lordship. 69-70.
Yes, yes.
Lordship.
What about that?
Lordship, they are saying there is a requirement of an experienced officer at Rishikesh. They are posting me prematurely before my term from Namsai to Rishikesh. But at the same time, in the same posting order, they have posted at serial number 1, Ravindra Dutt Raturi in my place. And Lordship, he has 26 years of experience. I am a fresher. I have just 3 years of experience. Their requirement is of an experienced law officer. They are uprooting me, whereas he was co-located. He could have easily been put there. This is, Lordship, this is what the harassment and bias which is being given. I'll draw your attention slightly at page 68, the previous page. Lordship, if you see serial 6, in that, if you see the second last line below, all executives except ET at serial number 6 will be eligible for transfer benefits.
Where? Which?
Page 68, Lordship. 68. The second last line. All executives except the ET, that is me, at serial number 6 will be eligible for transfer benefits as per the rules of the corporation. That means in my previous transfer, which was just 2 years back, I moved all the way from Pipalkoti in Uttarakhand at my own expense. They could have waited 10 days because they wanted to trouble me. And they just said, you are going home. But that is not an excuse for denying me. I had to pay for my own luggage. And specifically, they have mentioned, I might be coming near home, but I should get my due. If they would have posted me on, instead of 10th, on 24th of January, where I would have completed my 1 year, I would have been eligible. This is how they are depriving me.
Okay, to be eligible to get the reimbursement.
No,
You are-
they have refused because they said that you are falling short by 10 days. Now the point is,
Let me complete the sentence, Mr.
So,
Counsel.
Lordship.
Please hear me also.
Lordship,
What I'm saying is that in order to be eligible for reimbursement,
Lordship,
you are to complete a certain period of time.
Lordship,
You fell short of that time. So you were denied that
Lordship,
reimbursement.
Lordship.
What is the full form of ET?
Executive trainee.
Executive trainee.
Trainee.
Training.
Trainee.
Training or trainee?
Double E. Lordship.
Double E.
Double E.
So you are at the initial stage of your appointment.
Lordship, I would have completed it just after 10 days.
So what
After
can be
10
done
days.
at this stage
So,
now?
Lordship, I know, but this is just an instance of how they are depriving me. Lordship, if I were also to take your attention to my leave, to my transfer order, Lordship, that is at page 69, page 71, Lordship. Page 71. Now, page 71, Lordship, I was on leave for my mother's illness. She was seriously ill. I was on leave from 26th December 25 to 17th January 26. Now, what they did, once I have taken a formal authorized leave from them, what they did was they sent my transfer order on 2nd January, which was during my, Lordship, if I may be permitted, the Malicious Act, which was on 2nd of January, and they asked me to report on 9th of January. They know I have come for my mother's illness, and they are troubling me, sending me a transfer order when I am on leave, and asking me to report when I am within my leave period. And there is no urgency, nothing. This has been a series.
What is the report date?
Now the fresh transfer order.
Not fresh.
Lordship.
The 2nd January 26 order.
That
Does it say anything, any date?
No, after that we
Then-
filed a writ petition, Lordship. And
No, you are saying the malicious part on their part.
yes,
While you're on leave, you are supposed to go on transfer.
that was
But-
7 days. It
but-
is given out there, Lordship.
Where?
It is given out there. Lordship, may I draw your attention to
Come to page 69.
Yes, Lordship.
Automatically relieved from the respective post after 1 week from the date of issue of this.
7 days, Lordship, 1 week.
Okay, so 7 days.
7 days.
Okay.
So these are a series of malicious. And in my representation, Lordship, there were 6 officers, legal officers who joined in the batch of 22-23, my batch. 3 girls and 3 boys, 3 females, 3 males. Both the females have left because of all these reasons. I am the only female left now. And one of the males has left. The only 2 male who is still in the company is someone or both who have not been transferred even once, whereas this is for my 3rd transfer, Lordship. Similarly situated, same batch, the 2 males. These are a sequence of harassment and malafide intentions. Lordship, now in that speaking order, they have asked me to report, and they have said that I will report within 1 week. Generally, it is given, for others, it is given that he'll be relieved within 1 week. For me, I've been said that you will report within 1 week. And 1 week means they sent that e-office mail to me at 7:30 in the evening on 30th of July. Evening, after office hours. 2 intervening holidays, Saturday, Sunday. That means actually they are giving me only 3 working days. This again forms a series of this malicious act. And this has increased, Lordship, after respondent number 5 has joined, Lordship, so after who since his taking over has systematically attempted to trouble, and for no other reason except that I am a girl and I am hailing from the Northeast. Lordship, in these circumstances, I have been coerced and I'm left with no option. At 28 years, if I have to leave a job, they are coercing me. And therefore, I am approaching the Lordship, this honorable court, for justice and just interim protection.
Yes, other side.
Action in this regard. I'm representing Union of India.
Oh, Union of India.
Yes.
Okay, then as a CGC, you'll represent one, only one.
Only one, only one.
What is the nature of this?
Transfer. Sorry,
No, this company,
this is a PSU.
PSU, correct? But what kind of PSU is it?
This is dealing with hydropower. Power project.
Hydropower.
Hydropower.
Hydropower. What is the full form?
Tehri Hydel Development Corporation, India Limited.
Tehri.
Tehri. It initially started off there. Now they are all over India. They call itself as THDC India Limited.
Are they amenable to the jurisdiction?
They are amenable. They are.
They come under Article 12.
Yes, because they are not coming under CAT. And they are a state as per the definition of state.
This is your second round.
This is, Lordship, this is,
The earlier round was disposed of at the motion stage or what?
no, sir, Lordship, it was at the admission stage
Uh.
because the respondents approached and then we agreed on this thing that they said that please give a fresh application. So in good faith, we gave a fresh application.
Okay, please write. Heard, Mr.
DS Bhattacharya.
P.S. Bhattacharya. DS.
DS.
D.S. Bhattacharya, learned counsel for the petitioner, who submits that this is the second time the petition is before this court. Stop the first writ petition being WPC number 307 of 2026 was disposed of by order dated
24.
24/6/2026 by directing the petitioner to submit her representation against the order of her transfer for consideration of the respondent authority concerned. Stop. This such representation was to be submitted within a time frame and was to be considered sympathetically and also taking into account the fact that the petitioner is a female. Stop. The representation was then directed to be disposed of by giving the petitioner a chance to be heard as well, if she so desires. Did you desire or not?
I desired, I asked for a spoken this thing. They did not accede to my request.
Until such time the representation was not disposed of, the interim order granted to the petitioner would subsist. Stop. Person thereto, the petitioner submitted her representation. But despite seeking for personal hearing, she was denied of the opportunity, and the respondent authority concerned passed the speaking order dated 30/7/2026. Bracket annexure.
Lordship, it is at annexure 3, page 59.
Bracket page 60, huh? Not annexure. Bracket page 60,
Lordship.
by which the representation of the petitioner stood rejected and she was directed to join the place of posting within a period of 7 days from the issuance of the order. I agree if the petition is again before this court. Next para, the learned counsel for the petitioner submits that the transfer of the petitioner is in violation of the transfer guidelines of the respondent company.
Lordship.
Inasmuch as a normal tenure of posting in a particular place is for 5 years, and the petitioner has not completed the said tenure. Stop further. The petitioner, on account of family problem, on account of on account of medical ground, on medical no, on account of
Family.
family
Others-
problem, family problem,
Medical issues.
or family problem, on account of family medical issue,
Lordship.
had sought for permission to take leave, and she was accordingly granted leave from 26/12/2025 up to 17/1/2026. Stop. However, during her leave period, the impugned transfer order was issued on 2/1/2026, asking her to join the new place of posting within 7 days from the date of issue of the said order. The learned counsel therefore submits that grave injustice has been caused to the petitioner in the manner in which she has been transferred from our place of posting. Next, para, in view of above, issue notice of motion returnable by, give a date, 3 weeks.
Lordship,
3rd September 2026. Mr.
Lordship, in the
S. Kakoti.
S. Kakoti, Lanet CGC, accepts notice on behalf of the respondent number 1.
Lordship, may I be permitted? Lordship, till the time the next notice is served, I might be permitted to stay in that place.
I have not completed the order.
Lordship, my apologies, my apologies. Lordship.
Uh, Petitioner to serve. You have a copy?
I have a.
An extra copy of the petition to the land CGC within 2 days.
Lordship,
So far as the remaining respondents are concerned, petitioner to take steps for service of notice by way of speed post within 3 days.
Lordship,
Next, para, having regard to the above projection, it is hereby provided in the interim that you have not moved.
Lordship,
You have not moved.
We have not moved. I'm still at
Status quo.
status quo.
Status quo as on today shall be maintained till the next date of
Impugned,
listing.
Lordship, impugned. Lordship, they have given me a release order today or last evening. This thing after office hours. So,
Instead of that,
implementation-
you said having regard to the above projection, the speaking order dated 30/7/2026
Lordship,
shall remain state till the next date of listing.
and all consequential.
And
all consequential.
consequential is not there.
Lordship,
You have received today, but it's not available in report.
Lordship.
Okay, let's have a shorter date. I think it'll be better.
Lordship, we will issue notice and whatever date you say. Lordship.
Second or third?
Third
Which date you gave? Oh, you say third? Okay, it's okay.
Lordship. Much obliged, Lordship.
Yes, who's there?
May pleasure.
What is your case?
The petitioner is the wife of the deceased, who died in harness, my lord, and seeking, my lord, all, my lord, income retired benefits, from the department. Department has not, my lord, released the said amount, my lord, to the petitioner, showing the ground that the mother is also, my lord, filing application seeking all the benefits by her, my lord. At this stage, my lord, notice will go, my lord, to the respondents and let her come, my lord.
Who is the government servant?
My lord, Joinal Sorka, my lord.
Huh? Husband?
Husband, my lord.
Husband of the petitioner?
Husband of the petitioner. And father of the petitioner
And
number 2 and 3, my lord.
Who are the family members? Next of
My
kin?
lord, next of kin is in that at my lord. 2 sons, my lord. Petitioner number 2 and 3 are the son and daughter. And respondent number 5 is the mother.
What was he working as?
High builder, my lord.
Late Jamil Sarkar?
Jamil Sarkar, my lord.
Sarkar or Sakar?
Sarkar, my lord.
R is missing.
Sarkar.
R is not there in page number 4.
My lord.
You should be careful in drafting your. Heard, Mr.
MK Harma.
M.K. Sharma, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner prays for a direction to the respondent authorities to release the service benefits and all other dues of her late husband Sri Jamir Sarkar, who died in harness.
On 30/8/2025.
On 30/8/2025,
My lord.
while working as
Havildar, my lord. Under
Police.
responsibility.
police Havildar
My lord.
under the respondent number 4. The learned counsel submits that this is home guards.
Home guards, my lord.
He's from the home guards
Home guard, my lord.
or a police.
Home guard, my lord. Under district commandant, home guards, Dhubri. Page 5, my lord.
It's kind of above issue notice of motion to turn over by 4 weeks. Mr. So-and-so, that state government pit accept notice on behalf of respond of
1, 2, 3, 4.
respondent numbers 1, 2, 3, and 4. Number 5 is not staying with you.
Not staying with me, my lord. Separately.
Petitioner to take steps for service of notice upon the respondent number 5 by speed post within 3 days. Extra copies of the writ petition be furnished to the learned GA within 2 days. List again after 4 weeks
Pendencies shall not be.
to resolve the issue. Yes.
Highly obliged, your lords.
What is that?
Well.
What are you giving?
My lord, this is the instruction from government, my lord.
Regarding what?
Order, my lord.
Instruction is for you.
My
Why should I read it?
My lord, on the file last order, my lord, the instructions was directed to placement. Up to date instruction, what is going on, my lord?
Contempt.
Yes, ma'am, contempt, my lord. But the direction was given to the chief executive officer, my lord, to forward the proposal, my lord, to the commissioner, my lord, and thereafter to take the appropriate order, my lord, the steps, my lord. And that part has already been done, my lord. Now it's pending before government, my lord.
Mr. S. Dr. Learned Counsel for the respondent number
My lord, respondent number 1, my lord.
1 submits that he has received instructions in terms of the last court's order dated 11/5/2026. And he may be allowed to file the same by way of an affidavit.
Right.
Please file it.
My lord.
The prayer is allowed. Next para.
Please, your lord.
You're for the petitioner.
Yes, your lord.
Let him file the instruction so that you can have a copy also.
Yes.
And further, it is seen that as per office note, postal notice sent to respondent number 7 has returned back with a postal remark. Insufficient address to return to sender.
Yes, yes, yes.
Oh, I'm sorry. This is 34. Okay. In view of above, list this matter, that part you can sign.
It's been to my.
List the matter.
Only 2 responded, my lord.
My lord, both
Yes.
the respondents, they have left their post very long ago, my lord. They have to
Well-
complete the new incumbents. I'll file, my lord.
When will you file?
My lord, actually, both the respondents, they have transferred.
Hmm.
So he have to complete the new incumbents so that I can file, my lord. Because the respondent number 1 now is the district commissioner of Jorhat, my lord.
Maybe, but you can still file.
I can
Ask
have
while-
access to him right now, my
Huh?
lord. Because I'm the standing counsel of commissioner only, my lord. The Panchayat department.
But this is a contempt petition. You appeared on behalf by way of Vakalatnama, isn't it?
My lord.
Not by way of your position as a GA. So you can file. What is there?
I'll
You can swear there Vakalatnama there where the
Right.
commissioner in the district and they can send it to you.
my lord.
List again after when?
4 weeks, my lord, because I have to take from Jorhat, my lord.
Short date, my lord.
Give a date.
No problem.
7/9.
My lord, my name may be shown, my lord. I'm Islam, my lord. My name may be shown,
Where? In the order?
my lord.
Why?
My lord, I think it is non-appearance, my lord. Initially, I have not.
I never said, I've never said that.
Highly obliged.
Your name is already there in the file, Vakalatnama everywhere.
Highly obliged.
You want your name everywhere.
I'm grateful.
This is the one with that remark.
Yes.
What to do? Respondent number 7.
Yes, Lordship. Lordship, any short date may be given. In the meantime, we will confirm the address of the respondent number 7.
Okay, notice on respondent number 7 has not been served. From the office note, it is seen that notice as there's a postal note with a remark, open inverted comma, insufficient address, return to sender, close inverted comma. Counsel for the petitioner submits that she may be given 10 days time to verify the correct address and take fresh steps. Prayers allowed. List again.
Any date, Lordship, last week of August.
Give a date.
I'm obliged, Lordship.
I'll have to rise what to do. There are still some matters, but I can't take it up. So we'll have a date.
Yeah, my lord, in item number 24, my lord, I have received affidavit from the government, my lord. So may be fixed next week, my lord. I am without salary, my lord.
My lord, actually, I should be more.
Yes, all right, no problem.
Decided as to be.
I am responding only.
This matter was remanded by the division bench for a de novo hearing by your lordships by impleading him as the respondent. And the parties were allowed, my lord, to change pleadings by the division bench while the matter was remanded, my lord. So far as he is concerned, he has filed the pleadings, we filed the reply. So far as the government is concerned, just 5 minutes ago, they have served a copy on me. So if advised, I will have to definitely file a reply to response to that, my lord. My client is at Lakhimpur.
Okay, how much time will you require?
2 weeks minimum. Lakhimpur, my client is at Lakhimpur.
This is item number 24.
24, my lord, it cannot be listed before other bench.
No, that's correct. That's correct. That is correct. That has been by an administrative order. That has
Release
been
the matter again after 2 weeks. In the meantime, the parties are at liberty to exchange pleadings, to complete the pleadings. Okay, give a date. Any date.
Any Tuesday or Thursday, my lord, so that matter can be disposed.
Huh?
8 September. Mongolbar.
Lordship. I think it taken.
8 September, huh?
Yes, ma'am.
Instead of 2 weeks, you put that.
Hand over to be made to dispose on that.
And
Be given, my lord. Otherwise, my lord, it is not
Uh,
been done.
an endeavor shall be made to dispose of the matter on that day, on the next day.
Last.
Remaining, you get a date if
Last.
you want, and if you want adjournment.
Lordship, item number 29, your lordship, this is urgent, can it be posted on 7, my lord?
Take it up with the court master, she'll adjust the dates, okay? I have
7,
to
my
rest.
lord.